very good morning to you all. Thank you very much for coming, and welcome to the IEA and the Institute of International Monetary Research Monetary Conference, the 2017 Monetary Conference. We have a very exciting day ahead, focused on financial regulation. Do we need financial regulation? If we do, to what extent? What's the timing of the implementation of regulation and so on? We have the speakers coming from the US, from continental Europe, from the UK indeed. So let me welcome you all to the event. I'm going to play a video with a summary of what the Institute of International Monetary Research does. We established the Institute in 2014 in collaboration with the University of Buckingham. We're a very small institution, but we do a lot. That's what I want to think. And we specialize in money banking and central banking analysis. So I hope you enjoyed the sessions today. We will welcome your contributions in the discussion time, and again, enjoy the day.
Welcome to the Institute of Economic Affairs and the Institute of International Monetary Research Annual Monetary Conference 2017, sponsored by the Royal Economic Society and the Institute of International Monetary Research. So who are the Institute of International Monetary Research? The Institute of International Monetary Research has been established in association with the University of Buckingham. One of the main purposes of the Institute is to promote research into how developments in banking and finance affect the economy as a whole. The Institute's wider aims are to enhance economic knowledge and understanding, and to seek price stability, steady economic growth, and high employment. As a distinctive feature, we pay particular attention to the effect of changes in the quantity of money on inflation and deflation, and on boom and bust cycles. The Institute is an educational charity. You may wish to visit our website to learn more about the Institute's research agenda, or take a look at our latest publications, or register for any of our upcoming events. You can also view one of our many videos on subjects such as the Great Recession and debunking the myth. So here are some of the things we do. Recently, in collaboration with the University of Buckingham, we have launched a new master's programme, Money Banking and Central Banking. This is a one-year, full-time master's programme, but it can also be taken over 2 years as part-time study. We also provide professional courses on money and central banking, recently to delegates from the National Bank of Angola, who came to Buckingham. We provide monthly monetary updates, a series of notes analysing the latest monetary trends in the world's largest economies. We also email out our newsletter, which gives you links to all of our research and our news. Please donate to the Institute of International Monetary Research. It doesn't matter as to the value of your gift, but the giving of your gift does matter. Thank you. You can also follow us on social media. You can find us on Facebook, on Twitter, and on LinkedIn.
Tim, would you like to talk to us?
Quite a lot by way of introduction, and thank everybody for coming, and also very much for the work that people have done on their papers. There's been a lot of work done on these papers, so I'm very grateful. I have to say, I think they may become a conference volume, I hope so. I have to say, edited by Juan and Forrest Capie, I have to say I think you've got a lot of work ahead of you, but still, all the same, thank you very much for your contributions and hard work behind them. We should just thank the Royal Economic Society, and also today is going to be a real treat. You may not have twigged this, but there are 3 speakers in each session, and they've got rather different views about the subject. So I hope we get some good discussion. Thanks.
You have your lapel.
Okay. Well, we're going to have 3 papers in this session, but unfortunately Philip Booth is unwell and can't be here to present his paper, which is a great pity because it looks very interesting, and you have got copies of it. He suggested we might like to read it out, but I don't think we'll do that. But I can't help but draw your attention to a couple of the points that Philip makes. One is the scale that regulation has reached in recent years. And he points out that the UK financial regulator brought in or issued guidance, discussion documents and consultations totaling 4.3 million words. That's 5 times the length of the Bible, apparently. And Philip gives a lot of information of that kind. The PRA, the successor body to the FSA, produced documents explaining its philosophy when it comes to regulation. And the bit on insurance was 10 times as long as the insurance, the act that governed insurance in 1870. Indeed, the list of typographical errors in the EU Solvency II regulations was longer than the 1870 Act. And so it goes on. So it's a frightening thing. The other thing to say about his paper, though, is on the program it says, is financial regulation necessary at all? And that appealed to me greatly. But in fact, in his paper, he starts off by saying, I needed another word in that title. What he meant to say was, is government financial regulation necessary at all? And his paper gives a lot of history on the self-policing, the self-regulation that was spread through the financial sector over more than 100 years, and points out how successful it was and how much of that has simply been replaced by state regulation. So it's a shame Philip's not here to fill that out, but we have 2 speakers in the session, and they will each be given slightly longer to present their paper, and we'll have slightly longer for discussion. And so first is Rosa Lastra, and Rosa is talking about the balance between domestic and international regulation.
Thank you very much. Thank you very much, and I will be sitting down. Can you hear me? Yeah? So it means that the microphone is working. First of all, my thanks to Juan Castañeda and Tim Condon for inviting me for this timely event. And also it's always a pleasure to be here in this room with many familiar faces, Maria Nieto, Charles Goodhart, Mike Kriminger, and all the others. And what I'm going to do in this first session, since other sessions will focus more closely on capital, is to kind of reflect, provide a revisionist account of why do we regulate the financial industry at all, why do we regulate banking more intensely than other financial institutions, have we learned anything from the financial crisis, or are we, after the financial crisis, regulating some of the elements of the balance sheet even more strongly, and perhaps or missing some others which may lead us to the next crisis. So I will start. I have a background in economics, but I'm mostly a lawyer, and I'm a professor of financial law here at the University of London, at Queen Mary University of London. And one of the things that the legal approach, I think, always provides, or should provide, is some degree of logical coherence, which together with the empirical evidence that economics provides should hopefully lead to better laws and regulations. So that's the aspiration, where we are in reality perhaps is a distant, goes a distant way from this aspiration. Remember when I did my first studies of banking regulation. Well, I did my study in central banking with Charles Goodhart, but my studies of banking regulation started in the US 25 years ago. And I remember that I thought this is an extremely complex system, and it's very, very prescriptive. And I thought, well, at least in Europe, we have a more streamlined system. That's no longer the truth. The system that we have now in the UK and in the EU generally is as complex or more as in the US. So I think, that this is a reflection. We have At that time, it used to be said that the UK rely more on general principles, and though there is a lot of talk about judgment-led regulation and supervision, the truth is that we have become very, very prescriptive, and the balance has tilted towards greater prescription. So, some definitions. So, first, what do we mean by regulation, and what do we mean by supervision, and what do we mean by this balance between the national, the European, the international, which obviously is a very timely topic in the life of Brexit, or rather life after Brexit, what will be the relationship between the different levels, and what is the appropriate level for regulating and supervising financial institutions that many of them are still cross-border in terms of their activities. Obviously, we can reach in future, I don't think that will be a desirable scenario, a deglobalized world and a deglobalized system of financial institutions. We still have global financial entities, and therefore, when we talk about regulation, we need a system of global rules. So sometimes I think there is a confusion about what regulation means, the difference between regulation and supervision, conduct, prudential, macro, micro. So I'll just try to provide some definitions. So regulation in a very broad sense is the establishment of rules, the rule-making process. That's regulation, as opposed to supervision. And this encompasses both acts of the legislator, so that's usually what we refer as legislation or acts, sometimes the law, the banking law, or the financial law. But it's also an act of regulation, the rules. It's a set of rules with different types of intensity and enforcement. And also some of them are more primary, some of them are more secondary. A distinction that sometimes is also made with regard to rules. So these are both acts of the legislator, where they emanate by Congress, Parliament, however we call the legislative power in each country, and they are statutory instruments or rules of the competent authorities. This is typically what most people would regard as regulation in terms of governmental regulation. So those are the rules that emanate from the agencies, whether that's the central bank or whether they're supervisory agencies. Now, in this country with the FSA and the PRA, the multiple amount of rules that emanate from those authorities. In the US, we have Mike formerly with FDIC, and with FDIC, the Federal Reserve System, the SEC, they have been very busy over the years, issuing a very, very large amount of rules together with their other powers. But what complicates the picture, and this goes a little bit to what Philip Booth also was saying, is that also within regulation, we have a great degree of self-regulation. And what do we mean by self-regulation? Again, here we have different categories. We have, cooperative bankers associations or traders association, like, the ISDA master agreement, that you could consider that there are some sort of self-regulation or master agreements. We can have, the stock exchanges, they have their own rules. So there is a great amount of self-regulation. And sometimes we refer to that as market regulation. Market discipline is different, because market discipline can be advocated both by self-regulation but also by government regulation. Again, I look to Mike Kriminger, a lot of the things that in the US have been done in recent years is to try to foster market discipline. So market discipline is not necessarily equivalent to market regulation or self-regulation. Market discipline can come via a statutory regulation or self-regulation. And then this is only if you wish looking at the national jurisdiction, but we know that that's no longer the case. Rules come from many other sources, sometimes top-down organizations like the one we know the best, the Basel Committee on Banking Supervision. There are very many others. IOSCO, International Organization of Security Supervisors, IIS, International Association of Insurance Supervisors, and a very large panoply, like a mushrooming of these soft law entities or standard-setting entities that are often under the umbrella of the FSB, the Financial Stability Board, but they do a variety of other things. I call them top-down because it's usually meetings of officials, in Basel, IOSCO meets in Madrid. At the same time, you have the bottom-up. So again, these are rules that anyone that works in the financial industry needs to contend with. But these rules, they are no longer national. They are either European or international. There is, of course, a distinction between the two. We all know very well, and that's perhaps one of the reasons why Brexit happened, that there is a large amount of regulation that comes these days from what the newspapers in this country refer to as Brussels. in fact, is for the European Union institutions that, together representing the will of all the member states, enact a number of regulations. These, we are now very familiar, everyone in the city these days talk about MiFID II. So these are a series of directives and regulations that have permeated everything in the financial industry, from derivatives to hedge funds to securities. So obviously, it's no longer banking. These are all rules. They're important rules. They're actually enforceable rules, because one of the things that has happened with EU law is that it's directly applicable upon national law. So this set of rules, this set of European rules, of which the City of London will continue to inherit, because as you know, the Prime Minister May has said is that, Theresa May, is that it will be like Control-Alt-Delete. Everything that is EU law will be UK law. So for a while, at least, if that indeed, that promise that that's how the Great Repeal Bill will happen, you can anticipate that those rules will continue to be here for a while. It's just that they will be, as they are now, they're UK law, because by being EU law, they are EU law. So they are enforceable. And I'm not going to talk about the Court of Justice of the European Union, but they are enforceable in both national tribunals and as well as at the European level. But then there is more to it. So there is the international dimension. And at the international dimension, other than the IMF, which is really monetary, there is very, very little what we lawyers will call as hard international financial law. Extremely little. That means extremely little enforceable. So whatever we have at the international level, and I know today's, and Mike Kreminger is going to be talking about the Basel rules and the different implementation, but this is important to understand. Whatever today we refer as international financial regulation is mostly, I would say 90% or 99%, I don't know what percentages to apply, but to a very, very large extent is soft law. So here is the difference between hard law and soft law. Hard law is directly enforceable by the traditional means of which we understand enforcement. Soft law is not enforceable by the traditional means. That's why sometimes it's called observed by peer pressure, by name and shame, by eventually by the incorporation into domestic law, European law. And that's where you can have a difference in implementation. So the US can be more or less restrictive in how it implements Basel III. It never actually implemented Basel II. So that's one of the great euphemisms that exist. Basel II never became law in the US. But Basel III, if or when it becomes law, it may have a very different variation from what in Europe we have. I don't invite you to look at the document, because I am not in favor of Brexit, as you may know from my accent, but that document almost puts me in favor of Brexit, So that's called the Capital Requirements Directive 4. That means that there has been 3 to 1. And the Capital Requirement Regulation, which is, as you know, the difference in EU law between a directive and a regulation is that regulation is binding in its entirety, and a directive is only binding as to the means to be achieved, but leaves freedom to the member states with regard to their implementation. So we have an extremely complex regulatory field. I became a student of banking and financial regulation, as I told you, in the US, in Harvard Law School 25 years ago. And I remain a student, because though I'm now a professor, every day when I open my computer, I get news from some new rule making, some new act, some of which you have to learn before I can teach my students about it. I actually have to continue to learn. It's an ongoing process, which has not stopped at all. The opposite, it has multiplied in an exponential basis after the financial crisis. But it's still important to understand soft law and hard law, because when we talk about Basel, it's soft law. So we could either choose not to implement it, that remains at least a legal option, even if it will carry some other sort of sanctions or quasi-sanctions, that people don't have to give you market access, that name and shame, peer pressure. But that's what it leads to the different implementation in the US and in the EU and eventually in the UK, how we actually put into national law these soft law recommendations. So very, very complex. So all this is the world of regulation. On top of that, because in other industries you don't have this idea of supervision, supervision is very much of a banking concept and increasingly also financial concept. So supervision, again, in the same way as regulation, you have a broad sense and a narrow sense. With supervision, we also have a broad sense and a narrow sense. So supervision in a broad sense is a process which has different stages: licensing, authorization, chartering, then what I call supervision stricto sensu, which is effectively the monitoring of the health of the institution, making sure that they comply with the rules and the process of enforcement. It also includes more. Supervision is also risk control, and that's not necessarily enforcement, it's risk control, control of the risk that entities take. Sanctioning and crisis management, and I know there will be discussion about lender of last resort. I may say, if I have time, a few words about the end of how much ELA, emergency liquidity assistance, or lender of last resort, has changed after the crisis, deposit insurance, resolution, and insolvency proceedings. If we thought that we didn't have enough categories, after the crisis we came up with a new category, which in a way has always existed, because some of the macroprudential supervision instruments that we now call macroprudential, they have existed in the past. And some instruments, depending on if you want to use them for a single institution or a group of institutions, can be micro or macro, like counter-cyclical capital buffers, or like lender of last resort, you know. So in the same way as kind of supervision, what I will call a stricto sensu, we kind of know what it is, the monitoring and the risk control, the observance of the rules and enforcement. When it comes to the difference between macro and micro, and perhaps people in the audience can correct me if I'm wrong, is fluid. You know, it's not like easy categories. I mean, there is, when I look at, I wrote a chapter on macroprudential supervision, and there are very many definitions of what you understand for macroprudential supervision, because actually the end goal, which is to control systemic risk, you also have many definitions. So there is not a single definition of systemic risk, and there is not a single definition of macroprudential supervision. I often draw these for my students, you know, but it's not perfect, you know, because some entities, for instance, AIG, you could say is micro, is looking at the institution, but they have, you know, macro effect. So, but it's kind of looking more at the markets, while, you know, micro is looking more at the entity, at the individual entity. Like any analogy or economic model is not perfect, but at least it shows the reality. There's a difference in perspective. Ignacio Angeloni wrote a very nice lecture, a speech. He gave a lecture and then wrote a speech on this. And he wrote, you know, sometimes it's the same, but it's the difference in perspective. And I think counter-cyclical capital buffers is one of them. So having tried to define more or less what we understand by supervision and regulation. Oh, one thing, I refer to multi-level governance, MLG, and it comes in my title. Let me just say a few words about that. Multi-level governance is a term that was coined by trade theorists. And they say that you have different levels at which to regulate an activity. And those levels are the national, the supranational, and the international. And different types of activities should be regulated at different levels. And the test for that is a test of subsidiarity and externalities. And so subsidiarity, we all know, we have an intuitive, you know, as close to where the action takes place as possible. Externalities, we also know very well, unless the action has such effects that it's better to regulate it at a higher level, the higher level being supranational or regional or international. So multi-level governance has been very useful to understand in trade things that should be regulated by WTO, and again, WTO is becoming ever more important in this country, which is also my adopted country, but there are some things that are better done at the national level and some things that are done at the regional level. So multi-level governance is actually a very useful concept to look into banking and finance. There are clearly things with cross-border banking and financial institutions where national law is either insufficient or inappropriate, and therefore we need international rules. The argument goes, and we will revisit it, that if we conclude, and it's a big if, but if we conclude that markets need rules, like Ronald Coase or Douglas North, both Nobel Prize laureates and many people after the crisis can conclude is perhaps not so many rules, but that markets need rules, then it follows that international markets need international rules. So I'd like to revisit, just to go into what I would say some recommendations for what should inspire the regulatory agenda going forward, both in the context of the UK, but also in the context of international rulemaking going forward. What is the traditional rationale why we justify financial regulation? What it makes in banking regulation that is even more than financial regulation? So again, we all know, and now in this country with the PRA FCA, even though it's not a clean distinction, because as we very well know, the FCA also does prudential of all the entities which are not under the umbrella of the PRA. But anyway, as an objective, as a function, the prudential rationale is both the protection of the individual and the protection of the system. That's the prudential rationale. And the individual is depositor, investor, policyholder, effectively the consumer of financial services. I'm not going to go into the rules. A lot of them, particularly with regard to capital requirements, are going to be discussed in detail today. And then we have the systemic considerations, which have changed very dramatically after the crisis, in the sense that before the crisis, it was thought that really systemic prudential rationale came more from banking institutions because of the interbank channel and other transmission mechanisms, while securities and derivatives markets were not so prone to systemic risk. The crisis showed that this was not true. Systemic risk can arise from banking, can arise from securities, derivatives, it can arise from other markets. And that has changed the regulatory structure, because we used, and also capital applied to institutions. We used to think of too big to fail. And too big to fail was related to size and banking. Now, the terminology is SIFI. SIFI is no longer just size, and is no longer just banking. A systemically important financial institution, and there are many variants, and I will not bother you with the variations. The FSB is very busy these days enacting constant rules, which are obviously soft law on the different DSIBs and GSIBs, but SIFIs has altered the debate. It's no longer just banking and size, it's interconnectedness, it's complexity, it's the modern world of finance. So it has altered it. The conduct regulation, market regulation, has also changed a lot after the crisis. Even before the crisis, post-Enron, there has been much more attention on fiduciary rules. Kind of conduct and market. Conduct looks at the entities, is a little bit like micro supervision, and market is more like the macro supervision that we apply to banking. So again, these concepts, these regulatory concepts are evolving. But at the conduct level, it's the classic themes of prohibition of insider dealing, market manipulation, but the responsibility of senior management and fiduciary rules, in part because the ethical background that requires now a different banking culture, are increasingly relevant, not just from the FCA perspective, but an international perspective. And again, it's not a clean division between the prudential and conduct. Many will tell you that, or many of you will tell me, that conduct can also be prudential, conduct risk can be prudential. So, obviously, in banking we have all these, but we have more. We have also the monetary rationale, which being this institute and Juan Castañeda invited me to present, I love this quote from Ricardo. The distinctive feature of the banker, said Ricardo, begins when he uses the money of others. As long as he uses his own money, he's only a capitalist. When we talk later on, and Mike will talk about capital, many people say that capital regulation is very low these days, because compared with corporations, the thesis by Ahmati and others, where they say that the traditional corporation will have 30% of equity and 70% of debt. Perhaps, obviously in banks, because of their particular business, too much capital is not necessarily the solution. I'll come back to that. I know I'm controversial here, but I'll come back to that towards the end. Anyway, and obviously they're the major part of the money supply. There is all this her phenomenon this day with Bitcoin, and you can really see, the traditional euphoria of Kindleberg and Minsky building up, you know, but I think we're still a long way from this being a threat to central banks. But, you know, I may be wrong. But anyway, the euphoria about Bitcoin, I think, is more like an asset bubble than anything that would compromise the existing system. The prudential rationale, systemic rationale, I like also very much this quote from Galbraith: in times of bonanza, financial markets are a retreat from reality. In times of crisis, from financial markets are a retreat from sanity. And again, we could see that very well during the recent crisis, when the debt spiral of prices just led what is the market value when there is no market. And then the problem is this latter point. So in addition to all of this, which is more strict in banking than in finance, and this we all know, it's just good to revisit it. You know, we sometimes expect of banking, and there has been a lot of discussion, social objectives, because banks are supposed to serve the needs of the community, and then you also have efficiency, competitive equality, avoid undue concentration of financial resources. And bankers sometimes claim this is too much. You know, we have far too many goals, far too many things. You know, as a profit maximizing entity, are we also going to have to fulfill this function? So the idea of a public interest in banking, which arises because of the features, which I'll just again revisit, particularly with the payment system, is something, for instance, the Community Reinvestment Act in the US has been blamed for the rise of subprime loans and eventually building the terrain. I agree with you, Mike. I can see you nodding. But you have to agree that many of your colleagues make that point. Anyway, the issue is there are social objectives that are sometimes attached to banking. The last point is something which is going to be discussed. Sometimes regulation is not just the solution. So to actually have more and more rules is not going to solve the various problems that we have. There are other instruments, tax policy, better corporate governance, competition policy, better competition in the US, antitrust, anti-fraud laws, others that do not necessarily need to imply greater regulation. After all, the economic arguments for regulation, the natural monopolies, externalities or contagions, information asymmetries or deficiencies, if anything, have been reinforced after the crisis. And I mentioned before the externalities, and you know, clearly with information asymmetries, the case of banking is more acute than other financial. I'm not going to talk about this because I am aware that I will be soon completing my time. But just going back to what I said at the beginning, when I was in the US, I thought, oh my God, you know, the US is so prescriptive. You know, at least in Europe, we have some way to go. Well, there is no escape. In Europe, these days, we are as prescriptive, I wouldn't say more, but we are as prescriptive as the US, no matter how much we talk about judgment-led supervision and the different emphasis on having, you know, the pillar 2 and all that. We become very prescriptive, and anyone that works in a central bank or a regulatory agency can testify that this is the case. And so, well, these are traditional types of regulation, and I'd like here to, well, preventive, protective. I always like to remind myself, my students, and wherever I talk about regulation, that there is a direct relationship between the amount of preventive regulation and the amount of protection granted or expected. So if an entity expects to be protected somehow from some public authority, then it should rightly expect a greater degree of intrusive, quote, quote, intrusive regulation. And after the crisis, this has become the case. And for instance, these days, as you know, the Financial Stability Oversight Council in the US can deem any institution, whether it's a hedge fund or any other sort of financial company, as systemically relevant and put it under the supervision of the Fed and under the authority of the Orderly Liquidation Authority. And obviously, there is this problem of the extension of LIs and the extension of emergency liquidity assistance. It's going to be discussed in other sessions today. But again, it goes back to this bullet point of the direct relationship between the amount of preventive regulation and the amount of protection granted. And I mean, the defining feature of central banking in the second part of the 20th century was, the defining function was monetary policy, and a monetary policy targeted towards the objective of price stability understood as inflation control. That's no longer the case. The defining function of central banking during the crisis was the provision of emergency liquidity assistance, whether via monetary policy instruments, open market operation, or quantitative easing, or sometimes direct assistance to markets. And the goal is no longer just price stability, but equal financial stability. So price stability and financial stability have become the name of the game, in my opinion, in the 21st century of central banking. The law is lagging behind. Laws still reflect, for instance, the famous Maastricht Treaty still reflects a very old-fashioned understanding of central banking, where it says that the central bank shall achieve the objective of price stability, and the main instrument will be monetary policy, understood as interest rate policy. This is what the law says. It will take time to change it. Things in the US and in the UK have been able to change a little bit with greater flexibility in bringing financial stability to the same level. In the case of the ECB, that's not the case. Market discipline, I said at the beginning, market discipline can be at the government and can be a self-regulation. I like this quote of Alan Greenspan, because I call it Alan Greenspan's mea culpa. He had always said that, that regulation, not always said, but he was not very sympathetic sometimes to some of the elements of banking regulation that populate the US financial and banking industry. And called to testify in the House Committee on Oversight and Government Reform, he said, obviously that was October 2008, so 23rd of October 2008, we all remember October 2008, or we should remember. I was actually teaching a class, and I was telling my students, you should all remember, and they all look at October 2008, because obviously for us it seems like yesterday. Is almost 10 years old. Those of us who have looked to the self-interest of lending institutions to protect shareholders' equity, myself included, or in a state of shocked disbelief, utter disbelief, how is it that self-regulation, how is it that this didn't work? So, some problems and then some recommendations. It's very difficult to actually decide how wide and how deep to cast the net. So the issue of boundaries. So obviously, once that you establish a boundary, and I wrote a paper with Charles Goodhart, well, he was first to write the paper, and then we wrote another paper together. But how much do we want to regulate, and how many entities? And once that we put a line, once that we put a perimeter, like in territorial waters for fishing purposes, then outside you have the non-regulated market. Outside you have the non-regulated institutions. So wherever you draw a line, wherever you draw a boundary, you're at the same time establishing the shadows, all the shadow banks, the shadow markets, the shadow institutions, which will be much less regulated. So sometimes when we talk about capital requirements, one of the things that we say is that in order to meet capital requirements, banks have to either increase the numerator, very difficult in times of crisis, or decrease the denominator, leading to deleverage, leading to less access to credit provision, and therefore leading to other platforms, peer-to-peer lending platforms, or microfinance, or, these days everyone talks about DLT, distributed ledger technology. So you create shadows, and also you create loopholes, which is always for lawyers that becomes a source of income. Where do you draw the net? What are therefore the shadows, and what are the loopholes? Because wherever you draw the net, there will always be some loopholes. It's difficult, but
2 minutes.
2 minutes, yeah. Regulation should be designed in good times to avoid over-regulation. Regulation after crisis tends to have a vindicative character, this is never going to happen again. So we're going to stack more capital, and more capital, and more capital, or we're going to create, further defenses. It's not the best time to regulate after the crisis. Even that is when there is the public acceptance of regulation, is after the crisis, isn't it? But regulation should be designed in good times, a little bit like the biblical story of Joseph that has been taken in other purposes for provisioning and procyclicality or counter-cyclicality. We need to find ways of being able to enforce soft law better in order to establish competitive equality among markets for global financial institutions. And I'll put it to question since I'm only given 2 minutes and I want to say a few other things. And are regulators behind the curve? Yeah. Confidentiality in banking, duty to disclose insecurities. This is very important. And for instance, whether it's the provision of emergency liquidity assistance or capital requirements, in banking we tend to have greater provisions of confidentiality. The duty to disclose informs all securities regulations. So there is a contrast there when we expand the regulatory net. Then I will not talk about regulatory capture. I'm sure many people will talk after. Complexity and cost and incentives, I will leave. I will finish with some other concluding observations or recommendations. When I actually came to study at the LSE, one of the first papers I wrote was Edward Kane on good intentions and unintended evil. It was an article of 1973 about the selective case against credit allocation. And I have always thought that this is so insightful. A lot of regulation is good intentions and then it creates unintended evil. So there is not a bad intention in the regulator, it's just that it creates unintended evil. And since many of you will talk about Basel I and Basel II, I could explain how this reflects in Basel I and Basel II. Then I would also say that we need a more holistic approach to balance sheet regulation. I am the first to accept the importance of capital and the importance of liquidity as defenses. But the essence of the banking and financial business still is the investment and lending decisions that entities take. So we need this holistic approach to balance sheet regulation and not just focus on capital or even capital plus liquidity, which are defense lines all the times. So CAMELS, I have always liked since I lived in the US, the acronym, which is obviously not the cigarette maker, but capital assets management, earnings liquidity, and the S for sensitivity to market risk. And then the last point I will say is that international solutions require international problems. This is a favorite point of mine. So if banking and financial markets require regulation, then international banking and finance require international regulation. And we are still a long way from achieving the comparability and credibility that often cross-border financial institutions wish. Thank you.
Thank you very much, Rosa.